It's Angie Paradisney, Angela Paradisney. I had a full start there with the audio. I will continue and share with you an update by a journalist, the only mainstream journalist who followed the Carl Beech trial every day and has some pretty shocking things to say about it. I've got permission to share this, thank you.
Abuse. And I suppose their reporting led to the setting up of, which has various strands, Westminster, as it were, being one of them, wrote about somebody who is known by the name of Nick, who went on trial himself over the past 3 months or so. He was charged with attempting to pervert the course of justice and with making a fraudulent compensation claim. And a couple of weeks ago now, he was convicted on all counts and was sentenced just over a week ago to 18 years in prison.
With the Nick conviction, there's been a lot of talk about this over the last couple of weeks, actually. And I think it was Monday before last, the sentence was, or the conviction was announced, and then last Friday, the sentencing. What do you think, how sound was this case? Because I know there was quite a lot that the jury were not allowed to hear by the judge.
Yes, well, I do have real concerns about the way the trial ran, which leads, in my view, to the convictions being essentially unsafe convictions. My concern falls into two broad camps. Judicial rulings on the one hand and material relation to the evidence on the other. On rulings, there was a ruling before the trial started that the prosecution was going to be allowed to tell the jury about the fact that the defendant, Carl Beech, had pleaded guilty earlier this year in a separate case to downloading and possession of indecent images of children. Now, normally, as I'm sure you're aware, you cannot tell a jury about any previous convictions because of the risk of prejudicing them. And my view was that that ruling was highly prejudicial, and quite frankly, it didn't really matter what evidence would surface in the case. The jury was always going to convict him because they'd see it through the prism of his being someone who had downloaded indecent images. Terrible as that is, it looks like an absolutely heinous crime that he definitely did commit by downloading those images, and one charge of voyeurism. I believe that the jury shouldn't have been aware of that and should have assessed the evidence of attempting to pervert the course of justice on that evidence alone, and there shouldn't have been the prejudicial point about the previous convictions. Separate to that, there was a ruling about evidence relating to Harvey Procter. There'd been limited disclosure very late in the day to the defence by the prosecution, which related to the leak investigation into Harvey Procter in the 1980s, around 86, 87, and in relation to the property search that was carried out under Operation Midland, i.e. the investigation into Nick's allegations. The property search carried out on Harvey Procter's home in March 2015, and the defence wanted two things. They wanted further disclosure on this material, because, as I say, they had limited disclosure. And they also wanted to be able to cross-examine Harvey Procter about it, about these two elements. And basically the judge said no to both. So I think those rulings are critical to the way in which the trial was shaped. But I also think that there were some problems with the evidence. We know that, and we certainly knew at Exeter that the Met considered Nick, Carl Beech, to have been a credible witness, and we knew that well before they publicly said so. But what the trial never heard was the basis for that assessment by the Met officers on the case. It's been widely talked about. There's been this widespread assumption that the Met simply automatically believes their witness because that's the police policy. But in fact, that's not true. I mean, it is the police policy, and that is true. What isn't true is that that is why the officers believed him. There's more to it than that, and the trial didn't hear about that. And the other thing that the trial didn't hear anything about was any insight into the possible effects of childhood trauma. Now, the prosecution attempted to, what their speculative case was that here we have someone who was interested in downloading indecent images, and that was why, by their account, he made up all this stuff about abuse by VIPs. However, in my view, there is clear evidence that he certainly was sexually abused in his childhood, putting aside the issue as to who by. he certainly was sexually abused in his childhood, and that, of course, the traumatic effects of that, we simply had no evidence as to how that can manifest itself, for example, in how such a person gives an account of what happened to them, and indeed in relation to behaviours that can follow on from that past. So I think the trial was very troubling in the way in which it was conducted, and I think it means that the end result cannot be relied on.
So does that mean, do you think, Mark, that there may be an appeal after this?
Yes, I mean, it is possible. And my understanding is that is something that the legal team on behalf of Carl Beech are looking into. But they haven't made a definite decision on that, and I suppose they don't have to. My understanding is that you have 28 days from the point of the conviction, which, as you said, was the Monday before last. I think I got that right. 28 days from then if you want to appeal against the conviction, or 28 days from the sentencing if you want to appeal solely against the sentencing. And I suppose the areas of appeal that I certainly think should be advanced will be over the rulings, the refusal to force a greater disclosure on what Operation Midland found and on what other investigations found into allegations against various VIPs, and the rulings that shaped this case in terms of blocking cross-examination over certain matters of Harvey Procter, and the initial ruling about allowing the jury to know all about the previous convictions that Carl Beech had.
So, I mean, there's a lot to take in there, but I think maybe one of the most striking things about this case is why were the jury not allowed to hear why the Metropolitan Police decided, after having a look at Nick's evidence, or Carl Beech's evidence, that actually that there was definitely something to it. I mean, that was their conclusion, and it seems strange that the court would not be explained to the court.
Well, I think there are two elements to that. I mean, one, I think from the defence point of view, they kind of hoped that would become clear. There'd been full disclosure on material gathered by Operation Midland, but because it's clear they only had, well, they said in court they had very limited disclosure. I mean, I did tweet the figures at the time. I think one of the witnesses referred to how much material there was and how much material had been disclosed. It was a tiny proportion of the Operation Midland material that was actually disclosed to the defence. So if they had full disclosure, then the defence would think that it would become apparent from that why it was that the police officers took him to be so credible. And indeed, infamously, of course, the police actually said publicly in the early stages of the investigation that they regarded him to be a credible and true witness.
Is it simple when in these cases like this that really this is about one lawyer against another, and about how good and clever and well funded one legal team is than the other one? Because I would imagine that Carl Beech doesn't have quite as much clout and money as some of the people he's up against.
Yes, I mean, I think in a sense there's an element of truth in that for all cases. I mean, anybody who is being tried and in charge is up against the resources of the state, and they're reliant on their own resources, and with that some assistance from the state, of course, in the form of legal aid, but not really comparable. And I suppose that battle is a little bit more equal if you have significant resources yourself. So I think that's a point that can be made in any case. I think here the disparity of ours was not so much about resource, though, as access to information. As I say, the defence team were often acting in the dark. I remember I'll just give you a little example of how that manifested itself. There was a reference to a schedule of items that were seized from Harvey Procter's home by Operation Midland in March 2015, and one was a reference to a notepad that was seized relating to child sexual abuse, but it wasn't specified what exactly it was. And it was just a list of items. Of course, the defence wanted the items themselves so they could assess, what was there. And the prosecution actually stood up and said, well, we can't give you these items even if we wanted to, because we don't have them anymore. We gave it all back to him. And the judge, before he made his ruling on this specific point, this specific application, did say that he made this point that, well, I'm completely in the dark. You're in the dark, referring to the defence team. I'm in the carried on. There was a particular officer who had seized all these items, and the judge said perhaps we ought to have this officer back to tell us more about all this, but it never happened. So there were these great black holes in the midst of the trial.
What about the sentence of 18 months? I mean, this is in some of the commentary, years. That this is actually likely to have a chilling effect on any survivors of child sexual abuse thinking of coming forward, because, and also, of course, on potentially on the reporting of this sort of thing as well.
Well, there's several points there. I mean, first of all, it is possible for attempting of course justice to get a life sentence. So in one sense it could have been worse, but in another sense I think if you think about sentencing practice, I mean I think it's a very heavy sentence, 18 years in total. That's the prison sentence. That's the sentence that he received, although he will serve half of that in jail and will be released on licence, unless something else changes, but that would be the normal course of events. In terms of deterrence, I mean, I do think that, clearly, if you're guilty of something like this, then you deserve to be convicted and deserve to go to jail for it. The question comes down to whether you're guilty of it or not. And I think, I think one of the things one has to remember is that anybody who comes forward to make claims of sexual abuse, almost of any type, but certainly from childhood in particular, it has such a damaging effect on such a person that the way in which they behave and the way in which they recount their experiences do not fall into neat boxes in a way that people who are not familiar with this area perhaps realise. Now, the judge didn't make the standard warnings about not falling into stereotypes, but I'm afraid I think the whole case really shows that the criminal justice system is ill-equipped to handle evidence from people who claim to be victims of serious sexual abuse in their childhood. Because I think the other point I was trying to remember earlier that is crucial is we didn't hear any testimony relating to the possible effects of childhood trauma. There was no insight into whether this person who was in the dock, whether he was someone who displayed symptoms of actually having suffered child sexual abuse or not. Putting aside the issue of who by, but whether he was displaying those traumatic effects, or whether it was all put on, as of course the prosecution was seeking to establish.
And one of the cases that springs to mind after this, Mark, is the case of Gordon Anglesey. He was someone who was completely exonerated, as in some ways Harvey Procter could said to have been, of any kind of hints of child sexual abuse. And then afterwards it was discovered actually he had been a paedophile, even though he was a police superintendent. So these cases do have a habit of sometimes going one way and the other. I wonder whether you think that we've heard the last from Nick or Carl Beech.
Well, I think your point there goes to the issue of basically the criminal justice system is ill-equipped to get to the truth or to assess, whether someone coming forward to make allegations of sexual abuse, particularly child sexual abuse, they're very ill-equipped to handle it. And I suppose the case of Gordon Anglesey illustrates that, because of course one civil court one time basically concluded that the witnesses were lying and that he was not a sexual abuser of children, or had not been. And then of course many, many years later a criminal case came to the precise opposite conclusion. So I think the one thing you can be sure that this criminal justice system was wrong on at least one of those occasions.
So finally, do you think we're seeing, with the precedent set in these cases and new legal rulings and even new legislation, a slow change in the law with relating to child sexual abuse, and whether you think that it's moving in the right direction or not?
Well, I suppose one of the things that will happen is there'll be a concerted effort to sort of exploit this case to increase the pressure to stop naming those accused, for example, those arrested, or even I think to the point of being charged. And I think what that points to is pressure for even greater secrecy within the criminal justice system in Britain than we already have, which I certainly do not think is the answer. We do not need greater secrecy in our already overly secretive culture.
Mark, where can people follow your work? I know you've got I think it's www.foiacentre.com website, but where's the best place to follow what you're doing?
Well, I mean, it's probably best to follow me on Twitter at @markwatts_1, and if you look through there, you'll see the link to quite a detailed article that I wrote about that crucial ruling over the evidence relating to Harvey Procter, a full playing out of what was said in court about the evidence that the prosecution had disclosed in a sense, albeit in a limited form, what it was they were asking for. And I will, of course, inevitably be returning to the subject.
Okay, Mark Watts' website is www.foiacentre.com, and he's on Twitter at Mark Watts. And I'll put a link up to that article Mark's just mentioned there. It's,
okay, I'll share the link to this original video in the description, and I wonder if I could refer, well, you just have to look anywhere to see the kind of sentences being handed out to paedophiles, you know, including of toddlers and children, of a year, 2 years, 4 months, no sentence, and so on, to realize that this is, in my opinion, another huge miscarriage of justice. I do wonder whether Carl BEECH, who, let's not forget, is the son of the ex-head of MI6, the British intelligence services that operate internationally, MI6, his father, who he accused in his allegations very credibly, in my opinion. And also a point to make is that this push by VIPs that they not be allowed to be named unless they're convicted, that will be a huge blow to the truth coming out from survivors, because as we've seen with the success of, for instance, Shirley Oak's network, or the Nottingham Child Sexual Abuse Survivors Network, it's the fact of people coming forward that gives other survivors the courage to come forward. And then the police themselves can corroborate that many survivors give the same testimonies, that having never met each other. And yes, why were the police made to take the fall? Oh, you know, as Boris said, spaffing money against the wall on these abuse inquiries. You know, if the police said that we find his evidence to be credible and true, we find him to be a credible and true witness, you know, why on earth weren't there reasons introduced to the court? This is, you know, along with Sabine McNeil's 18 years, I haven't talked much about her appeal, but appealing the length of sentence to me is redundant. I really hope, because appealing the length of sentence is like saying, yes, I agree, I'm guilty. And to me, that's like if a bully steals your lunch. I know it's much more serious than that, but just bear with me a minute. If a bully steals your lunch at school, you don't get friends to come together and say, oh, can you please give him back half his lunch because he's lost weight and he's really suffering from not eating. You know, the grounds for Sabine McNeil's appeal, you know, appealing to compassion from the very people that, in my opinion, wrongfully jailed her in the first place. You know, what other outcome could there have been? But absolutely not. We should have given you longer. You know, it's just... So I do believe Sabine was very badly advised legally. And, you know, I do hope that Carl's, his 28 days must be almost up. I do hope that his legal team, I don't hold out much hope, because one will find the legal teams are often in cahoots with prosecution. The defense are often in cahoots with the whole system. But if they haven't done so, I do urge them to appeal the conviction and not just the outrageous sentence, which is making a laughing stock of the UK across the world, in my opinion. Okay,